Hello? Hello? Thanks so much, my lady. I am very much grateful for the time that we are granted in order to deal with this matter, so that we can put things into perspective properly after the interim order being granted sometimes last year.
Yeah.
My lady, I would like to maybe first make a request that, can I request that immediately after dealing with the issue of our point in Limine, may I proceed to deal with the entire case so that we don't do it in piecemeal?
When you talk about the entire case, you mean the whole
application?
I was not prepared to deal with it. Remember, I'm merely assisting in the reconsideration. The rest of it has to be heard eventually. This is simply a reconsideration of my interdict, restraining the payout of the pension funds. I can't deal with the entire, because I'm not prepared for that. And also I'm going back into court in my other matter. Just as soon as I'm done with this matter, they're actually waiting for me.
I'm talking about the reconsideration application, my lady.
Yes, we're dealing with the reconsideration. When you talk about your point in limine being what?
The agency.
The urgency, okay.
Yes, from there I will proceed to deal with the reconsideration that we have filed.
Oh, all right. So I thought you were dealing with the main applications. That confused me. Sorry.
No.
Okay. You okay. Proceed.
Thank you so much, my lady. My lady, the applicant brought this application on an urgent basis.
Yes.
Somewhere in October, if I'm not mistaken. But they indicate to the court that this matter.
October or September?
I'm speaking under correction. I think it's September. Towards the end of September.
It's September, yes.
Yes. They indicate to this court that this matter is urgent because the first respondent is likely to cash in her pension or to withdraw her pension.
Yes, according to the papers, they came to the knowledge that the payment, I think, was going to happen. And so they interdicted the payment.
My lady, what is not brought to this court's attention is whether there was an application for withdrawal by the first respondent. That is a very, very crucial issue which was supposed to have been addressed before this honorable court in order to seek or to get that interdict. But that was never made before this honorable court.
I don't understand when you say application for withdrawal.
When the first respondent was informing GEPF that I would like to withdraw my pension, they were supposed to have informed this honorable court to say, my lady, we have got a first respondent's request to withdraw her pension. So if we do not interdict this, she's going to use her pension, and we're going to be left with no liquid asset in order for us to recover whatever the loss that which I quote, the loss that they attribute to the former HOD.
Sure.
The period, they do not tell the court that as to when they became aware of the resignation of the first respondent. And my lady, the first respondent resigned sometime in June 2020. Sorry, in June 2022.
Was it not August?
That is when they first became aware. That is when the applicant first became aware of the resignation. But they do not tell the court as to when exactly they became aware of that period. And if the court can check page 275 in our answering affidavit.
Can you just bear with me? Yes.
At the top there, page 275, they refer to the letter of resignation. which is FA20.
Yes.
That letter is dated somewhere June. But the next paragraph, the respondents indicate, first respondent indicate to this honorable court that the applicant informed the SIU, not the applicant, but the respondent, sorry, the Office of the Premier informed the applicant on the 1st of August at 10:09 that she resigned, and the reasons were also indicated in the very same letter. My lady, I apologize. We see here the letter was not attached here with a stamp from SIU to show that the letter was received on this date, which is 1st of August at 10:09. And this issue, it is not in dispute by the applicant.
Mm-hmm.
So towards the end of September, that is when they launched this agent application, which is a period of almost 2 months. And they come to this honorable court, which is a very busy court on an agent basis, and say, yes, we are here. We want to prevent the first respondent from making a withdrawal from her pension fund. They do not explain to this honorable court as to what they were doing from the 1st of March. Let's just say for argument's sake, my lady, they became aware on the 1st of August. Let's just say they became aware of that resignation on the 1st of August. But they did not put this court into its confidence to say, we became aware on this period. This is when we became aware of the resignation, I mean, of the resignation, or maybe the purported withdrawal of the funds. If, my lady, they were saying we received the letter on the 1st of August. We did not do anything because we were waiting for her withdrawal, for her to maybe try to withdraw from the funds. It was going to make sense. But they do not even have an application for withdrawal from the funds, which maybe they could have used it to say it triggered the agency. My lady, the discretion, it is the discretion of this honorable court to grant an application on the basis of agency. It is, we have got a plethora of judgments which supports that. But we are of the view that the exercise of that discretion should be done judicially so. And a period of 2 months, if a court can have a problem with a week, a delay for a period of a week, well, what about a period of 8 weeks, my lady? We are of the view that that is very much excessive, and it should have been explained. And there's a lot of things which, when we are dealing with this matter going forward, my lady, today, I'm going to be trying to show this court that the applicant has been disingenuous from day one.
Okay.
My lady, that is
okay.
Our submission is that this matter is supposed to be dismissed on the basis of for lack of agency. There was no agency at all.
All right. Now let's move on to the substantive application for reconsideration. Let's assume that you have not succeeded on this point. Let's move to the other. On that, as you said, let's deal with both aspects.
Thank you so much, my lady. My lady, I believe that the court has gone through the heads and the files, so that I do not maybe.
But I think the most important thing is when you're asking me to reconsider, I interdicted the payout of the pension. Now, where in your papers do you say why it has suddenly become urgent for me to reconsider the payout of that pension? What is there in the papers? If you could just direct me to those paragraphs, I may have missed it. Because remember, this is a reconsideration.
My lady, what we are saying is that. My lady, can you hear me?
Yeah, yes, Mr.
Because the line is the line is a bit blurry.
Okay, can you hear me?
Yes, now I can. It's clear.
Okay.
My lady, what I'm saying is we are saying that in order for the applicant to have to get this application successfully, they must first establish a right. And what we are saying is that they do not have that right over the applicant's pension because she has done nothing wrong. She did nothing wrong at all, my lady. And for me to indicate that, my lady, I will have to go to summarily refer to the allegations that the SIU has made in line with the projects which they attribute to her conduct.
She has not done anything wrong. So simply on that basis, but aren't you now dealing with the substantive issues in the case against you? Because remember, this is a reconsideration. You saying I need my pension money. So I want to know where in the papers you're telling me why it's become so urgent that you need your pension money. That is what reconsideration is about. I'm not dealing with the merits of this application at this point in time.
Can I seek the court's indulgence so that I can refer to the court to the same paragraph where she will be indicating that she needs the money?
Yes. Ms. Thomas, if you Ms. Nkosi Thomas, she there?
My lady.
If you know where it is, just point it out, please, to assist us.
This is page 40, paragraph 41 of the answering papers. I'm currently, and it reads as follows. I am currently unemployed and my assets that I purchased on credit stands to be repossessed, including my residential property, as I will not be able to pay monthly installments.
That's all.
That is the one reference that we could locate at paragraph 41.
Oh, that, yes. Yeah, I've seen that. But what proof is there that is so?
My lady, the only proof is only when it is being disputed by the applicant that she has those things. We cannot just come out and be expected to produce a proof on things which are not disputed. If this court can check, Even on the replying affidavit, it is not contained there. They did not respond to this issue to say that she's been inconvenienced in this fashion. That is what was going to trigger a proof from our side. Because we are saying, we are alleging that this is what we are suffering. This is what the first respondent is saying she's suffering at this stage. Because she does not have any income. She doesn't have any. If this money is going to be kept there, this is the sufferance that is being projected by this application, by this order.
So she says the house is going to be attached.
That is something that will happen if she does not have money, because she has to.
This is my difficulty with this. You know, she has to come to this court with placing all facts before this court as detailed as possible, especially where financial circumstances are concerned. And a letter from the bank to that effect would have gone a long way towards supporting her version. Right now, I just have a say so that this is going to happen to me. I have nothing else.
But my lady, with due respect, if I say to someone that I am likely to suffer this and that, and nobody challenges it, it is my firm view that my word should be taken just the way it is, because there is no one who is disputing it.
Saying it's not disputed.
Yes, my lady.
Okay. Thank you.
And if we are to wait for this process, my lady, if we check, the SIU indicated, the applicants indicated that they've got 60 days to institute the action. Now it's more than that, and they haven't had done anything. So what is it that the applicant will be relying on for her survival? She doesn't qualify for social grant. She doesn't qualify for any means for survival, my lady, and that is what needs to be considered.
Okay.
And my lady, another thing, maybe if I should add, there is nothing that the respondent, that the applicant is going to suffer. If the applicant is supposed, let's say the applicant says, I am going to suffer because there won't be any liquid asset, they can still come after the asset which she wants to protect now and also to earn a living now. Because if she's going to pay the bond, obviously she's not going to sell the house. She'll be paying the bond, and when they want the money, they can still come and attack the property that she wants to preserve.
My difficulty with that is we don't know. Anything can happen between now and then.
But if the court want to order that she should not dispose of her asset, that can be better, but not to restrict her from using her funds, because it's just like putting a guillotine on her neck to say we are leaving out to dry. Whether you die or not, we don't care.
Okay, but did you see there? I'm just a bit concerned about that, because right now I don't even know what the outstanding amount on a bond is. I have nothing. You want me to reconsider? She might have a bond, but how much of that bond? What is the pension amount that is due to her? How much is that? How much is the bond that's outstanding? What is the extent of the rest of her debts? So how then will that liquid asset be protected? Because I don't know these details.
My lady, we just took a decision because it was not challenged. But now that since the court wants to know that if the court allows, we may seek indulgence so that we can provide the necessary documents that the court needs. And that will not be foreign, because the court has powers to request any further information in order to come to a proper decision. We can provide those documents. There are many more documents which we can provide, my lady, which will assist this honorable court. And I can still tell the honorable court that there is no one who's going to suffer, because even the applicant, because even the pension money is still there.
Okay.
If we are to stand it down, maybe to a certain date, we will provide those documents that the court wants, so that the matter can be laid to rest properly.
All right. And so what else is is that the basis for your application, that she really needs the money?
Even the grounds, my lady. I understand the court, even the grounds that were laid down in order for this court to issue this order.
Well, way I understand your defense to the action is simply that she acted in some form of necessity.
It can be partly, but we are saying that there is nothing wrong except in addition to that. We are saying,
as the accounting officer, you said she had she didn't have to play any oversight role in approving all these large amounts of payments to various service providers. Is that what you say?
No, that is not what we are saying. The oversight role is statutorily there. She has that role. What we are saying is she does not have a role to redo the work that has been done by the technocrats. My lady, if I were to refer the Honorable Court to the judgment which was confirmed in the appeal court, that is the judgment of Lucilla Rocher. In our heads of argument, we succinctly referred the Honorable Court to those paragraphs. My lady, in this case, this lady, Lucilla Rocher, was challenging the issue of the consistency in terms of discipline, saying that her supervisor was supposed to have been disciplined because she approved what Lucilla provided. The court, if I may read from paragraph 32, my lady.
Sure.
The court held that the arbitrator committed material errors of law and fact in applying the parity principle to the facts. At paragraph 88.9.1, the arbitrator held that Ford was equally negligent in failing to make proper disclosures as he contributed to the recommendation, as is evident from this extensive editing of it. So he should have been aware of its defects. This statement is irrational and flies in the face of the evidence. Rocher was the lead executive on the deal. She had dealt with it for months. Ford was a recent appointee, close bracket. She had traveled to the USA to meet with Walmart, a bracket. Ford did not accompany her. It is not clear why the arbitrator simply assumed that Ford should have been aware if Rocher misrepresented the extent of Walmart's commitment. He was, after all, dependent on her report in this regard. And trusted her implicitly to make proper inquiries and report honestly, and the exact nature and terms of Walmart commitment to the project. My lady, if I should just jump to the next paragraph, which I feel is important. Paragraph 88 of the same judgment, point 9.3, it reads that it is not clear to me that the arbitrator appreciated the seniority of Rocher's role or the fact that Ford merely exercised an oversight role as head of the business unit. Why the arbitrator held that Ford should have insisted on repeating Rocher's work is not clear to me, especially when Rocher had told Ford on the afternoon before submission was due, or close bracket, that the review was okay. And she highlighted the negative remarks and the problem raised within script review to Ford. One could perhaps have taken him to task for failing to follow up. My lady, if I were to bring this to the matter in Kasu, this case was going to be different had the former HOD, the first respondent, were in the report. If she was told that company so and so, Clinipro, Prosecure, NDIA, and MTN, maybe either of them or one of those three do not qualify, and she insisted to say no, let's appoint them, even though they do not apply, they do not qualify. So this is the essence of what this paragraph says. Then, with your leave, if I may proceed.
Yes.
But where a trusted and a senior employee assures a manager that a script review is in order, it is not without more incumbent on the manager to submit the subordinate's work to close scrutiny. This approach will be contrary to the environment of trust in which teams in a professional working environment normally operate, particularly when facing tight deadlines. My lady, this was a case of life and death. Nobody, which I can even say it without any doubt to this honorable court, that even this honorable court did not know how to treat this COVID-19. Whatever that we were doing every day, it was just a trial and error. My lady, if I can just, the court can take a judicial notice of how people were behaving in that particular moment. Whatever that they were doing, they were trying to save lives. So, my lady, if I were to refer to another paragraph which talks about the oversight role, which the court was asking, if we read on page 527 of the bundle, paragraph 12, it says condonation of irregular expenditure.
Just a moment. Yeah.
With the leave of the court, may I proceed to read?
Yes.
Condonation of irregular expenditure. Irregular expenditure may be condoned if there is evidence that the accounting officer,
took.
My eyes are now deceiving me. If the accounting may be condoned office, if there is evidence that the accounting officer took effective and appropriate steps against any person found to have caused it. My lady, I would like to refer to what my colleague referred to you to. That is section 81, subsection 1B of the PFMA. My lady, that section cannot just be read in that fashion. Subsection 1A, subsection 81 1A says that it precedes 1B in the sense that the accounting officer must have failed to take steps in terms of section 38 up until section 42. My lady, if we are to go to section 38 of the PFMA subsection H, that section, my lady, empowers the HOD to discipline any person who has misconducted herself or himself financially. So it cannot be that if when the first respondent has disciplined, currently as we speak, my lady, I am in the process wherein the first respondent is disciplining those technocrats of which she relied on their report. So it cannot be that everyone must be disciplined.
No, I thought she resigned. So how is she disciplining them?
My lady, when she left, the process was in place. And it's still on as we speak.
Oh.
She's the one who commenced with who started the entire process.
Yes.
The process started somewhere. Thank you, my lady. So what needs to be understood, my lady, is that the buck needs to stop somewhere. The buck needs to stop somewhere. It cannot be that when she's disciplining someone who has done wrong, who is alleged to have done wrong, she must also be disciplined. Then we must also say the MEC must be disciplined. We go to the premier also. Even the minister, we discipline the minister. And then we go to the presidency. The entire country must be disciplined in line with their work. But the buck needs to stop somewhere. My lady, I will accept it or it will make sense if maybe she did not institute those proceedings. Whether at the behest of SIU or whoever, but the issue is allegations were brought to her and she commenced the entire process.
Okay.
Then, my lady, if we also have to read, I think it's just a repetition of what we have gone through. It's a repetition of what we went. My lady, if I were to now go to the issue of the allegations themselves, let me start with Clinipro and Prosecure. This court has been made to believe. That everything that has been done here, like in this case of Clinipro and Prosecure, the first respondent did wrong. It is not true, my lady. Firstly, what the first respondent, the applicant tells this court is that Clinipro was not tax compliant. My lady, I am party to the disciplinary hearing that is ongoing, wherein Mr. Ramurunzi, the person who deposed to a confirmatory affidavit, considered in the hearing to say that Clinipro tax matter is not an issue. But now they bring it to the court in order to get the court sympathy and order and issue an interdict. That is very wrong. If I were to refer the honorable court to...
When you say it's not an issue, don't you have to be, in any tender process, don't you have to be tax compliant before you qualify?
They were tax compliant, my lady. They lied to you.
Okay. So
they lied to you under oath.
Clinipro was tax compliant.
Clinipro was tax compliant. I can refer this honorable report to...
Yes, so I've seen that.
The CSD report.
Yeah.
Thank you very much, my lady. Then, let's now go to the next stage. They say that no, Clinipro, I mean, the prosecutor and Clinipro were given an advantage. That cannot be true. My lady, this project of PPE, in particular, the sanitizer and sanitizer dispensers, when demands were coming every time, every minute, wherein Mrs. Ramakwahwa, the allegations were in the affidavit, wherein she is confirming that when I was busy sending requests to other suppliers, the end user was adding more items which they need. Then the quantity had to change. That is why Clinipro and prosecutor were sent different quantity. But what they do now, the applicant does to this honorable tribunal or the court, they come to the tribunal and say the specification was changed in order to give advantage to Clinipro and prosecutor, which is incorrect. My lady, they refer to the emails, the two emails which were sent to Clinipro and prosecutor. If we are to, it is not in dispute that the emails which were sent to Clinipro and prosecutor were not part of the submission which were given, which were approved by the HOD, the first respondent. I'm saying, if we are just to assume that whatever that was in those emails was wrong, she never saw those emails. That is just beside the point. Let's now zoom into the emails that they are referring to. My lady, Mr. Ramurunzi, the person who was in the hearing, under oath, he testified that the spec never changed.
The what never changed?
The specification was never amended. But in this application before this honorable court, they mislead the court and say the specification was changed. Which is wrong. And it's a plagiarism for that matter, my lady. Then, if we are now to go to, they even said that there was an approval before the end user could make a request. My lady, that is not abnormal in an emergency procurement. I refer the honorable court to page 552 of the bundle.
You know what? I don't have 552. I have 551 and then 553.
My lady, I spoke to my attorney in the morning. If the court can check, there's a blank page on 552.
I don't even have that.
In my bundle, there's a blank page. I asked the attorney to say, no, let's favor the court with that page because it is missing. When I checked, I could see that page was missing.
Yeah.
But however, my lady, we made reference to that paragraph, I mean, in our answering affidavit to say we are allowed to do that. First respondent is allowed to work without papers and paperwork being done later after the emergency situation has been normalized.
Okay.
If I were to read with the leave of the court, my lady.
Yes, sure.
That's the emergency procurement, paragraph 14.2.9.2. Verbal authorization to proceed may be given by the delegated official as detailed in the delegations of procurement authority. All supporting documentation, including emergency or urgent cases justification form, must be submitted together with the written instruction or order for procurement to the SCM, which is Supply Chain Management Unit, as soon as possible, but definitely within 48 hours of work or service. My lady, if we are to check the submission which was signed by the end user, the request by the end user was signed on the 20th of March 2020, which is 8 days earlier than this period as provided by this provision. They are permitted to do this in terms of this provision. My lady, let me, if I can just give an example. As I've indicated that this COVID-19 was an alien disease which nobody knew about, which I submit once again that we should the court should take a judicial notice of saying. To say, it's just like a case wherein they say the hospital is burning, or maybe the Department of Treasury is burning. We cannot expect that people sit down and start writing memorandums. The first thing in terms of this provision, you must call the fire brigade urgently to go and put out the fire. When you are done, come down and do the work and then do the paperwork. That is what the provision says. And same was done, and 8 days earlier than the service. My lady, another thing which they say no, there were other things which were like Prosecure and Clinipro were said to have quoted for manual and automatic dispensers. That cannot be true, my lady. If we check on the record here, Clinipro and Prosecure, they've indicated to the to the department that we cannot, in particular Prosecure, they said we cannot find automatic dispensers. That was during negotiations, and that was after all those suppliers who quoted failed to meet the requirements. If, with the leave of the court, my lady, can I refer the court to this submission which has the evaluation report as to how those other suppliers collapsed?
Mm-hmm. Okay.
Oh, thanks, my lady. Page 59 to 68. In particular, this is a submission which was given to the first respondent for her approval. If my lady can go to page 61. At paragraph 3.5, table 1.
Yes.
These are the companies which the department sourced the quotations from.
Mm-hmm.
Then only 4 responded. If we check at 4.2, administrative compliance,
mm-hmm,
we see, and then we go to the next page, which is important, phase 2.
Mm-hmm.
4.2.2, that is page 62. We see this is where we are going to find the companies that qualified or that were competing at that stage.
Mm-hmm.
They were now 4. Let's see. This, just before that, my lady, this submission was made after negotiations with the successful bidders. My lady might have read the memorandum which was sent by the first respondent to the investigator, wherein she was indicating everything that led to this process.
Mm-hmm.
If we check Clinipro, isn't that the applicant says that they were given an advantage for quoting manual? Clinipro, if we check company name, the next the next item is manual dispenser. At the top is written items quoted. Can the court follow?
Yes. Yes, but they quoted for automated dispensers, and then later they say they didn't have it. Shouldn't they have been?
My lady, my lady, I think my lady did not read it. That my lady did not read it well. That is not correct, my lady.
That's a submission you made. They said we cannot find automatic dispensers.
That is Prosecure, not Clinipro. That is Prosecure, my lady.
Prosecure.
Yes, not Clinipro. Clinipro said in that submission they indicated that they only deal with automatic. They don't deal with manual.
Yes, I'm talking about Prosecure.
If my lady can allow me, can I first deal with Clinipro? Then yes. I will go down.
Sure.
Let's see. Clinipro was sent an email to say that they must quote also for automatic, for manual and automatic.
Manual, yes.
Which SIU has a problem with.
Mm-hmm.
SIU is saying we asked the first respondent says we asked them to quote on automatic and manual because already we had an information that automatic was scarce. Then Prosecutor did not, Clinipro did not quote for manual. It is no here. It says no.
Yes, it says no.
They only quoted for automatic. And then the required percentage of sanitizer is 70%. Mm-hmm. And the verdict for is complied.
Yes.
If we go to the next, is Prosecure. Prosecure during negotiations is the one that came and said that we can only be able to find manual. Then in the submission, that is where it is indicated that they've got manual. And even though they've quoted for automatic, there were affidavits which were given to the investigator, Mr. Ramurunzi. And even in that particular disciplinary hearing, my lady, Mr. Ramurunzi considered to say, no, this issue of automatic and manual is not any issue. I see it came up during negotiations as per the HOD submission. By the way, my lady, this is not in dispute.
Mm-hmm.
Let's go to Masana and SIUvDR. Just because of sanitizer, if we just go to the next stage, Masana and SIUvDR did not quote for manual. But if we go to the sanitizer of Masana is 60%.
Yes.
My lady, even though we are not scientists, we all know, we have been informed during COVID-19 that it's only 70% a sanitizer that contains 70% alcohol.
Yeah.
They did not qualify because of the content of the sanitizer.
Yes.
Let's go to SIUvDR. If we go to SIUvDR, it says not comply. Let's go to the paragraph below that. It's paragraph 4.2.2.1. Mm-hmm. The following bidders failed to bid according to specifications. Masana quoted 60% instead of 0.5 chlorhexidine, gluconate, 70% alcohol. Mm-hmm. That is why they did not comply. Let's go to the next item, the next company, which is SIUvDR South Africa. They were disqualified. Why? They quoted a 5-liter steady spray for sanitizer instead of 0.5 chlorhexidine, gluconate, 70% alcohol.
Mm-hmm.
Then, in addition to that disqualification, the person who prepared this said they were also disqualified because of liters. My lady, we concede here, this was wrong. The liter, disqualifying the supplier based on a liter was wrong. However, a liter is just a bottle, an empty bottle, that's why we're saying the content which was going to be in that empty bottle was not going to comply. Whether they complied with the bottle, let's say they complied with the bottle, they were not going to make it because already they failed on the content of the sanitizer. Mm-hmm. I don't know if I'm making sense, my lady.
Yeah, no, you are.
Thank you very much, my lady. So that is the essence of Clinipro and Prosecure in terms of their disqualification. I mean, in terms of their being recommended and not being given an unfair advantage.
Being disqualified, yeah.
Yes. If we are to say, my lady, that they were given an unfair, we were supposed to have considered maybe Masana and SIUvDR, because they were changing now the manual, the sanitizer to manual, the sanitizer dispenser from automatic to manual. It was not going to assist because their sanitizer was not passing the spec compliance.
Okay.
Then, my lady, what the applicant did not tell this honorable court during their application is that they also have they have got a report The SIU has a report which they have written in 2021, which investigated this matter. That report, my lady, is found on page 293 of the bundle. Is Annexure TFM1. But
sorry.
And the relevant part is 360. If my lady can just check page 293, my lady can see that this is an SIU report.
Yeah.
Yes. And then if we just go to the last page, this report was signed by the SIU head advocate and Mutivi.
360?
No, not 360. I'm saying at the last page of the report.
Okay.
We are going to find that it was signed by the SIU head, who is advocate and Mutivi. Now let's go to page 360. What is
what, the 360?
360, yes, my lady.
Okay.
The paragraph 15.6, that's in the middle of the page.
Yes.